Hello, everyone. Welcome to another episode of The Clueless Capitalist, where we help you discover interesting startups, interview founders, and help you become less clueless with angel investing. My name is Razi.
My name's Osman, and welcome to The Clueless Capitalist.
In this episode, we've got Faith from fsLAW, a boutique corporate law firm in Singapore, and they have been ranked among the top Singapore law firms for startups and emerging companies by Chambers. Faith has over 20 years of experience structuring, negotiating, and documenting corporate and commercial deals, and she's completed transactions with a combined value of over $30 billion. So for this episode, we've got Faith to share with us what are some of the legalities when it comes to investing in a startup in Singapore. And I think this episode is especially necessary because I was just having a coffee with a friend last week, and she was asking me, hey Razi, what is a safe document? What is a care document? How do I invest? And what are the things that we need to look out for? So thank you for joining us and helping us shed some light on this, Faith.
No problem. My pleasure. Thanks for having us.
One of the things we like to do before we go into the episode proper is to always ask, what is the origin story? So how did you get started with startups and helping them structure all of these and get the documentation right?
Yeah, sure. So I guess I've been running fsLAW for about 10 years now, and fsLAW is really just my initials and then with the word law at the end of it. So it took me 5 minutes to think of the name of my firm. When I first came back to Singapore from Australia, I thought I'll hang out my shingle and see how I go. I was kind of fresh off the boat and I didn't know anyone. And I guess my origin story starts with a very kind venture capitalist. So I actually started on the venture capitalist side of things rather than on the startup side of things, which is maybe uncommon for a small firm. And this venture capitalist client was very kind, and I did a lot of deals for them. I'd been a corporate lawyer for a long time before that, but my real introduction to the startup space was acting for a venture capitalist.
When I was looking at the law firm's name and it was fsLAW, it didn't occur to me that it stands for your initials.
Yeah.
It's very interesting to hear. And then now that you have seen it from both sides, right, from the VC perspective and now also the startup perspective. So I think this is going to be a very interesting conversation.
Yeah. So, Faith, just for everybody out there that's watching this video, we hear these terms a lot. They're bandied around: safe note, care agreement, the convertible notes. Could you just give us a very quick overview as to what the key differences are, if there are any, are any interchangeable?
Yeah, sure. So I guess as a general comment, the safe and the care are both convertible notes. And convertible notes are kind of, a name for a broader category of these sorts of agreements. But the essential idea is it's a form of debt, and it's a form of debt which is convertible into equity. So it has elements of equity and it has elements of debt. And you can imagine, if that's really the fundamental thing between the care and the safe and convertible notes, there's a lot of room for customization. There's a lot of different types of terms you can have in these. So convertible notes, that's more of a broader term. Care and the safe, they're kind of a convertible note for a very particular type of situation. They tend to be for startups. And the concept there is that they have terms which are a little bit more startup friendly. As the name suggests, they've chosen these, acronyms to kind of convey the message that these are instruments which are safer or more caring from the startup's perspective. But of course, that means that maybe it doesn't always give investors, what they want in a convertible note. So perhaps the best way to show that is, to go through one of these cares or safes, if that might help.
Great. And before we jump into an example,
sure.
care note, we also hear terms such as pre-Series A, Series A startup, and what do they mean exactly? And is there a kind of a rule of thumb that people will typically talk about when they say, what stage are you at? Is it pre-Series A? Is it Series A? Is there a rule of thumb that you would typically go with?
Well, I guess it's not so much a legal concept. So for lawyers, we tend to be very precise. What rights and obligations are there? But I guess from the perspective of someone who's kind of seen a number of these sorts of various fundraisings, it seems to me that a pre-Series A round, or maybe a seed round, or an earlier round, might be one where you might see the founders putting in money, friends and family, or angel investors. That are really helping a business take its first steps. So it may be that, the founders have a great concept. They may have been laboring over it for a little bit, but they really want some cash, essentially, to put towards it to better ensure that the idea is a good one, perhaps to do a bit of market research or product development, or perhaps to just fund some part of their salary so that they can keep going with developing the business before it's revenue positive. A Series A is, as the name suggests, something that you might see after a pre-Series A. And that's where there's a little bit more meat on the business. And, you might be looking to fund the business with some form of a track record, and you might be looking to take next steps. So it's difficult to say what the next steps are. It really depends on the business. But, you're certainly sort of, you've got a proven concept. Perhaps you've got some customers already. I think these days, you'd want to be kind of having a degree of revenues as well to be able to show your potential investors. And in that Series A round, you might see participation by venture capitalists and more institutional investors rather than angel investors and friends and family. Does that kind of make sense?
Yeah, it does. So really, when angel investors are getting involved, it would be safe to say that, pardon the pun, but you'd be using a safe note,
yes,
or a care agreement, and then if the big boys get in, the venture capital firms, they're typically not going to use those types of instruments. Is that fair to say?
Generally, although I've seen sort of venture capitalists perhaps playing at the earlier stages,
yeah,
or wanting to do a quick deal in anticipation of Series A. And they'll use a safe as well, or they might use a care as well.
Got it. Yeah. I mean, one of the things which was brought up to me when we were talking about safe notes and care notes is how straightforward they are and how quick they can be executed. Just in comparison, for the listeners, I've seen equity price rounds with 300 pages of documentation. And a safe note or a care note is usually like 3 or 4 pages of documentation. So the name suggests it's safe, and it's care. It's actually pretty. With safe, it's a simple agreement for future equity, and for care, it's a convertible agreement regarding equity, I think.
I think.
Yeah. And both of them are meant to deal with being very simple, straightforward, and not complicate things too much at the early stage.
Yes, I think that's right. Although, I mean, the lack of some words can be good for investors or bad for investors, but they're kind of, I guess, there are a few major terms in the care and or safe, which kind of makes it a little bit quicker. So I think one of them is essentially pricing it by reference to the next round. And so then you're cutting out a lot of that negotiation between investor and the startup about valuation, because you're saying, well, we know we're going to need a lot more money later on, and we know that this particular investor is not going to be putting in that large amount of money, and they're kind of interested, but either they don't have the money, or they just don't do that ticket size. I want a quick deal where I'm putting in a smaller amount of money, and when it's converting into equity, well, I'll leave that to the larger ticket investor to take a closer look at things and to come to a valuation, and I'll trust that process to give me my valuation for my shares. Yeah. Does that sort of make sense?
Yeah, it does. And
yes.
I mean, in my experience, having worked on some of these agreements in the past, I've seen people present like a safe note that they've pulled down from the Y Combinator website, and then there's other agreements that I've seen. In this particular episode, we're going to talk about the VIMA agreement, which is a framework that I think it's Singapore Law Society, or is it the Venture Capital Society of Singapore? They've created a framework which is pretty standard now, and you can access that type of information online as well. So we're going to talk specifically around the VIMA agreement and the terminology around the VIMA agreement.
Sounds good. Sounds good.
Yeah.
It's actually, okay, we were on the VIMA 2.0 working group, so I better correct you slightly, otherwise I'll be in trouble with the Singapore Academy of Law, not the Law Society. The Law Society did comment on it, and it was like a multi-month, it was maybe even a multi-year project where they got a whole lot of international firms, big Singapore law firms, boutique firms like ours, venture capitalists like Temasek, and startup representatives as well. And there was a long process of commenting on these agreements, you know, and I suspect, you know, Singapore government's behind this, essentially, Singapore Academy of Law. It's part of a broader project to promote Singapore law, and Singapore as a good place to grow your startups.
Okay.
Just curious to know, like when we look at the VIMA documents, are they applicable for all of the VC financing deals or only for pre-Series A and seed rounds?
Well, VIMA has, helpfully divided it onto on their website. There's a suite for pre-Series A, and then there's a suite for Series A. But you know, you can kind of customize these documents for both. It really does depend on how far your pre-Series A wants to go in terms of the setting the framework for how the startup's going to be governed and doing things like that. So if you're an ambitious startup and you're at pre-Series A, but you say, I want to look ahead, what does it look like? And I want everyone to agree to that now. Well, go for your life. Have a look at the Series A docs.
Okay, got it.
Great. And just for everybody watching, we've got the link to the model agreements from the VIMA framework on the link on the ticker going below. Just in terms of the general framework of the VIMA agreement, the reason why I think it's really important that we talk about the framework itself is because when people start to share other documentation, there are items which are there or not there that should be there, and using a standard agreement and a framework from a reference point for VIMA makes it very easy to validate that the documents are comprehensive and they're in alignment with what I think at least everyone's got a common baseline to work from for an agreement. So I think that's fair. I think maybe we should go through a sample care agreement.
Here we are. Okay. So this is the care. For those who've used the SAFE, you might recognize some of these concepts, but you'll see that the style is a little different to the SAFE. The SAFE is more in an American style. This is more, English, Singaporean, Australian, Canadian style. It's more a plain English style. Sorry, my copy shows a markup because there was a CARE version number 1, which was for the VIMA 1.0 suite, and this just shows changes in VIMA 2.0. There's some helpful explanatory notes, if you want a good overview of CARE. And then we launch straight into the CARE itself. Of course, you've got here the two parties. You've got the investor who is putting money in and the company that's receiving the money. You have a few recitals here to, give everyone some background. Of course, one of the most important things is how much is the investor going to put in, and that's the consideration. In consideration for the amount that the investor puts in, the company undertakes all of the obligations in this CARE. So the CARE is quite helpful in that it bunches up together some of the key terms, and well, it's trying to be helpful at least in that it says, well, if all you want to do is adopt the CARE and you want to know, well, what I need to customize, well, come up with a discount rate, valuation cap, maturity date, these particular things they're saying, please focus on them and ensure you fill this up. But I guess to work out what these things are, it helps to read the rest of the agreement. So maybe what we'll do is let's scroll through, let's keep doing our page turn of this care to understand what these terms mean. In clause 2.1, that's one of the distinguishing features of the care and the safe from other convertible notes. And that's the concept that this care is going to convert if there is an equity financing. And that's, we were talking about that the key thing about the care being cutting through that valuation conversation by saying, well, you get the number of shares, and dependent on the valuation of the company that this investor for a larger ticket will be putting on the company. And so it converts in an equity financing, and the care automatically converts into a number of preference shares. And there are two ways of calculating that number of preference shares. One is we take the consideration, which remember is the amount of money that the investor is putting in, and divide it by the discount price. Okay, and let's see. We've got here this concept of a discount rate. So if you want to do this the professional way, have your definitions right next to you when you're reading the provision. Okay, so discount price, and is the lowest price per share in the equity financing applied by the discount rate. So remember this discount rate here. So I think essentially what we're saying is, one way of calculating the number of shares you're going to get is to ask yourself, what's the investor paying in the equity financing, and make it the lowest price per share that they're paying. And then in addition to that, give me a discount rate. So if the deal between the investor and the company is, well, there's no discount rate, you just get the price that the investor pays in the larger fund rate, well, then your discount rate is, I think it would be 1. Is that right? Multiplied by 1. So yeah. You just have to kind of watch the maths there. And otherwise, if you're getting a discount, well, make it lower, maybe make it 80%. If you're getting
usually I've been seeing a discount rate of 20%.
Okay, I think that's a mistake, I suspect. I think people mean I'm getting a discount of 20%, but when you track through the maths, you really should be putting 80% in
80.
there.
Yeah. So okay. I think in colloquial terms, like when we're talking, we talk about it as, I'm going to get a 20% discount. But on the care agreement, it should be put down as 80%. So that when you do the maths, it's like $1 times 0.8, and then then you get your discount value. So just for the listeners as well and the people watching, the reason why there is a discount is because as an angel investor, you're coming in early, you're giving the investor some money up front very early, and the risk is a lot higher for you as an angel investor. A venture capital firm coming in, let's say 2 years down the line, they've mitigated a lot of the risk the startup has anyway. And if you were to come in at the same price as the VC, what's your reward for giving your money at a higher risk? And there isn't, unless you get a discount. So the idea of a discount is to reward you as an angel investor on the fact that you've put more money up front at risk than somebody coming in later on. And that's usually the reason why you would have your discount rate applied here.
Yes, that's a very good point. Yep. Okay. And the care gives you the option for going one better than that. So it says, you could get shares based on some discount to whatever the investor is paying, or let's talk to a valuation cap. And that, again, we've got consideration here. So dollars divided by the care price. And if we go to our definitions here, care price is the price per share equal to the valuation cap divided by the company capitalization. So, you're looking there, and I think that is where, at the front, you've got a valuation cap here. So you fill that in, and that works in clause 2.1. And if you're kind of, you want to be absolutely sure, make sure you've got your definitions there as well to figure that out.
So just to explain to the viewers as
Yeah.
well, with regards to a valuation cap, again, it's a concept of being rewarded for putting in money earlier than other people. So a valuation cap is something like, let's say it's $1 million. So the company in the future, if it's worth $1 million, then that's the price that you will come in at to convert your consideration amount into shares. And a venture capital firm 2 years down the line might be coming in and saying, look, the company's worth $2 million. So with the valuation cap, it means that because I've given my money in early to the founder, even though the venture capital company is paying shares at a valuation of 2 million, your valuation cap is 1 million, therefore you're getting double the amount of shares compared for each dollar that you're putting in, compared to a venture capital who's coming in at a lower risk 2 years later. That's the concept of the valuation cap, is to kind of reward the founder as well for their earlier consideration. Is that right, Faith?
Yes, I think generally that's correct. I'm not so sure for the founders. There may be other instruments where they're rewarded, but this one certainly, the idea is to reward the investor for investing early, as you say, and taking on that additional risk. So there are really two ways of looking at it, and this is one where I think the investor and the company might spend a bit of time thinking about it and talking about it and customizing it. Do you go for both ways of calculating the number of shares the investor's going to get, or do you go for just one? And this one goes for both and says, I'll take the largest number of shares, thank you very much.
Yeah.
Okay, so that's 2.1. 2.2 talks about a liquidity event. This kind of answers the question, what happens if, when that equity financing actually occurs? And this 2.2 answers the question, well, what happens if something else happens before equity financing? Because it may be that there's a change of control in the company, and equity financing is no longer going to be all that relevant. So again, we go back to the definitions. You'll see liquidity event here means a change of control, an IPO or an ICO. I think let's focus on a change of control. I think that's more likely. Although even then, it's quite unlikely for a startup. But just in case, if somebody comes and buys more than 50% of the shares, so that's what A means, or if there's some sort of, merger of the company with another company, or if the company basically sells all of its assets and sells off its business, in that case, there's not going to be a need for a equity financing anymore. And in that case, the investor should get something out of it as well. And CARE says, and this is the default position, but of course, you can customize this, the investor will receive a portion of the event proceeds. So, and every time you see these capitalized terms, it's in the definition section, and you can go to events proceeds, but you can imagine it's just, talking about, well, if all the shares are being bought, how much is the acquirer paying for it? That's the event proceeds there. They'll receive a portion of the event proceeds, and then the question is, how shall we calculate that? Well, the CARE gives you the option of specifying a multiple. So it may be that some investors will say, well, in that situation, I want a hard multiple given how much I put in. Okay, maybe I want 2 times the amount that I put in, or 1.5 times, or 3 times. So this gives you the option of specifying some multiple. Or it says, let's do a calculation of the number of shares I would have gotten. And, then, pretend I were a shareholder at the time of this liquidity event. How much do the shareholders get? And I want that proportionate amount. So then that, of course, begs the question, well, how many shares would you have if you were a shareholder, because actually you're not. And it says, do that calculation again and ask yourself, well, consideration divided by the liquidity price. Liquidity price, you can see the definitions get a good workout here.
Yeah.
Liquidity price is the fair market value of the ordinary shares determined by reference to the purchase price payable in connection with such liquidity event. And then multiply it by the discount rate. So remember that discount rate concept when we were saying, well, we get a 20% discount on an equity financing. This says, well, hang on, if you're selling the company and we're going to calculate how much I get, pretending I'm a shareholder, I want that discount rate too. Yeah. But you can see all of this is, customizable. And perhaps actually one of the great things about the CARE, if you're using that and you're telling your counterparty you're using it, after you've customized it, they can very quickly do an electronic compare against the standard CARE. And at least both sides will just come to an understanding of how it varies from the CARE pretty quickly. Does that kind of make sense? All of this is customizable, of course.
Yeah. No, it does make sense.
I was going to ask, will both these options be present in a CARE document, or is it going to be either or? If you look at the option here, the consideration multiplied by the multiple.
Okay.
Are both there, or is it already
we're just going through the CARE now that's available on the SVCA website. And this provides for the greater off. So, if you pick a multiple, then, you do both calculations and you figure out, well, which is going to give me more money. And if that's not what the investor and the company intends, then you need to change it.
Understood. Yeah. Only one option. They don't get rid of the equal to or the greater or and just say this is the only option that's available.
Yes, you can certainly do that. Yep.
Yeah. I was just going to say, usually the point that you brought out, Faith, about being able to do an electronic compare between standard document and what's been changed, it would also give you an idea of whoever's made the changes, what their intent is as well.
Yes.
Because if they've taken out something, then they obviously they're either trying to limit their downside or limit your upside, and why would they want to do that? So you can start to interpret the intent from what's been put in or taken out from the document.
Yeah, that's right. And actually, just to manage expectations as well, I think generally the CARE has more bells and whistles, and when you compare that to the SAFE has fewer of these bells and whistles. And just because you're getting rid of some of these bells and whistles doesn't mean that someone's trying to cheat you or trying to give you a bad deal. It's just, I suspect that with CARE, the lawyers thought, well, I've seen it done this way, I've seen it done that way, let's put in all of this language. And, if another lawyer were looking at it, they'll know to take it out, and they're not going to get upset. They're not going to feel, offended because things have been taken out.
Yeah.
Does that make sense?
Yeah, it does. I had one instance where I'd noticed that a founder had different valuations for his company, and obviously that's a red flag in itself. But what I insisted on from their Y Combinator note, they didn't have an MFN clause in there, and I insisted on putting that in, and it was only because I'd seen the MFN clause in the VIMA agreement that I thought this is quite good. But maybe you could just give a quick explanation as to what the MFN clause is and what it brings to the investor and to the founder.
Yeah, I think I quite like the MFN clause as well. I think if I were an investor, especially if I'm really not putting in a whole lot of money, and I don't want to, the founder is busy, and I want the founder to be busy building the business rather than negotiating with a whole lot of smaller investors. So this essentially provides two things. One, it says the company represents to the investor that actually I've given you what, I provided to others as well. Because then I guess, you might take some comfort that, hey, others are getting the same deal. And, I don't want to rock the boat too much. I know I'm not putting in that much money. Okay. And the second thing it does is that it says, if the startup goes and amends things or issues further care documents, it's going to give the investor written notice and give the investor the documentation, the additional documentation. And the investor may then make a determination, and it may say, actually, I like the other care document, and please can I have that apply for my situation? And you can imagine that, startups will say, okay, I might want to look at this clause a little bit more to ensure that maybe you'll get the same terms if you're investing around the same amount of money. Because, often what happens is that you might have, even in a care round or a safe round, you might have a lead investor, and the lead investor is putting in a lot more money than others, and they may be getting better terms, they may be getting different types of protections, and it's not always realistic to expect the same type of protections. But you can imagine that, this is quite useful with a few tweaks from the startup's perspective to kind of cut through that negotiation, to build a bit of trust with your smaller investors. And, from the investor's perspective, again, just saving time. Does that make sense?
Yeah, it does. I mean, and the reason why this particular founder didn't have an issue with it was because, from their perspective, if they were giving out, the story they'd given me was, we're going to grow, we're going to be a lot more valuable. So it's unlikely that they're going to be giving more favorable terms to a future investor. So again, for me as an investor, I can validate what their story is. If they really don't want to do the MFN clause, for me as an investor, it kind of tells me that, okay, maybe the upside story that the founder is sharing with me is not as solid as they think. But generally speaking, it's just I think it's a good all-round clause to kind of develop trust and to cut out a lot of this uncertainty over, well, if I put in money today and tomorrow they need to give better terms to someone else, am I losing out? Well, if I've got this clause in, I don't need to worry about losing out to future investors. I can at least be in on the same terms if they're favourable. And I think maybe you mentioned this to me as well. This is a one-time only thing. It's not something that's in perpetuity. So it's not like they've issued a new round and then you can go onto that new term sheet and then a future round and you can go onto that. You can only execute this clause once. Is that right? Wrong?
This kind of applies prior to the termination of this care. And if you remember, if you have the correct type of equity financing and you convert, well, this care is supposed to terminate. So it only applies until, up to that equity financing that everyone's looking forward to and looking to convert, at that time.
Great.
So it shouldn't apply. Yeah. And again, I think as an investor, don't be offended if the startup says, yeah, okay, but I might need my lawyer to put in, a few more qualifications here, because you can see from the startup's point of view, they don't want to promise too much, especially if they've got a large lead investor, or there may be a large lead investor later on.
Yeah.
Talking about the maturity cap. So the maturity cap is the valuation, right?
Maturity cap is no longer used. I think maybe now they call it valuation cap. Is that what we mean?
Yeah. I saw in your document that version that you have is a valuation cap. The word maturity cap has been cancelled.
I think VIMA 2.0, you can imagine, you had a whole bunch of lawyers there. Somebody must have said, why don't we call it valuation cap instead? But you can see it kind of plays the same role.
What is a reasonable maturity date?
Oh, okay. Now, maturity date is a concept which you won't find in the SAFE. And I think the SAFE essentially assumes this is going to be quick. We know, and the investors are comfortable, that there will have to be a larger fundraising and it's going to convert in that way, right? So, but the CARE says, again, having a few more bells and whistles, the CARE says, oh, what if you have an investor who is worried about the equity financing not happening, right? So when you're thinking about, okay, should I have a maturity date at all? Okay, take into account the fact that, just because it's not in there doesn't mean you should be offended because the safe doesn't have it. And then 2, think about, well, what sort of runway would be reasonable to give the founder to go raise the amount of money that we're expecting founder to raise. Okay, maybe think about it that way. And then the other thing you might do is think about, well, what happens on a maturity date? And the default position in CARE is if there is, again, if the CARE doesn't terminate, which means if there isn't equity financing before the maturity date, on or after that date, the investor may elect to automatically convert into ordinary shares, right? And the ordinary shares, again, you look at the considerations, so the amount of money you put in, divided by the CARE price. And I think we saw that the CARE price, uses the valuation cap. That sort of makes sense?
It does. So then there's a question maybe more for Osman. So if let's say I'm an angel investor and I came in at a particular valuation cap with a maturity date, and the startup wasn't able to raise any further funds, and the maturity date happens and I get issued the shares, should I feel disappointed as an angel investor?
It depends on what your objective is, really, I think. I don't think it's a failure until the company goes bankrupt, because you're now a shareholder in a viable company. It's not a complete loss. Now, obviously, most angel investors, what they're looking for is like a 10, 20, 30, 50, 100x return. Maybe that hasn't been realized, but you're still coming in. The time frame for that equity financing has expired. The maturity date has kicked in. You then convert at the valuation cap at a discount, right? So the company is still valued at a particular amount, and so long as the company is valued higher than what your valuation cap is, then you've at least made, let's say it's like a discount of 20% or 80 if it's on the as it's written, you've still made 20% upside on your investment, right? So it's not, I wouldn't call it a failure. It's only a failure if you really had an expectation of making a 10x or a 20x, and this is not always the case. You never, I wouldn't say that every investment an angel investor is going to make is going to return those types of returns. So you shouldn't expect it anyway. And the idea of a care note or a safe agreement is that it at least gives you some upside. And in this case, with a discount rate and the conversion, you should have some upside. And then you're a shareholder, and you can, if you want, you've got the options then to do what you need to do as a shareholder. Either participate fully within the organization, try and do a secondary sale of your shares to somebody who's more interested, ask the company if they want to buy back your shares. All those options are then available to you. I don't see it as a failure. The only time it's a real failure is if a company goes bust, and unfortunately that's the risk that you take as an angel investor. There is always a high risk that some of these companies can fail.
Yeah. Another curious question is that, so the CARE document will terminate at which stage? Is this a Series B? Series A?
Well, it terminates on this equity financing. It terminates in various situations, but the one that everyone's looking forward to is the equity financing, right? So, okay, we can go to the termination clause itself, but I think it essentially says, if you get your money back, here we are. We are going to automatically terminate if either you get shares or you get your money back. And then, we're done and dusted. This document is really about either getting you shares or getting you money. Does that make sense?
Yes, it does.
Yeah. So it can kind of be used, theoretically it can be used at any stage. but it tends to be used at an earlier stage of the business when you're looking for a quick way to put money in, and you're trying to reassure the founder that it's not debt. It has fewer debt-like characteristics than other convertible notes. So this one, for example, in other convertible notes, you might expect to see a repayment obligation when the company must pay cash. And for a startup, they might balk at that because, well, that's a quick way to insolvency if things haven't quite gone to plan. And this default position, I guess, is one option instead. So it says to the investor, well, you have an option to become a shareholder instead, because this document is really quite short. It doesn't guarantee a whole lot of rights and obligations. It doesn't give the investor a whole lot of rights, and the investor might say, well, after 2 years, I think I'd rather be a shareholder and at least have some shareholder rights. Does that make sense?
Yeah, it does. In one of the startups that I've invested in, the maturity date has gone past, and I have now gotten shares.
Okay.
Yeah.
Okay. Good. Okay. So you used
congratulations, we should say, right?
Yeah.
Like what Osman is saying is now a shareholder of a viable business.
Good. Yes. Well, yeah, I think that's the main thing. Dissolution event, which is, a sad event. That's kind of if there's a winding up, in which case, again, the investor gets a portion of the event proceeds from that winding up.
Yeah. And I think it's definitely worthwhile covering this, because as investors, we're always thinking about upside, and as a founder, you're always talking about the upside. We very rarely talk about what happens if things don't go well. But yeah, let's look at the dissolution event and see what rights we have as an investor. Yep.
Okay. So in a dissolution event, let's pull up our definitions again, just to give everyone an idea of what dissolution events are. A voluntary termination of operations, so an assignment for the benefit of the company's creditors. That means creditors are taking all the cash, or any other liquidation, dissolution, or winding up. And to be fair, I guess, sometimes it can be a happy winding up. It may be a way in which they are selling their assets, or some of this may be used as a restructuring mechanism. But oftentimes, I think in the startup space, these things tend to be sad events. So kind of in a sad event, what happens? In a sad event, you get your money back, if there's money to be had. You're treated like a creditor. So you get your consideration back, which is the amount of money that you put in. So you're treated like a debt holder in that event. Does that sort of make sense?
Yeah, it does. So basically, best case scenario, if the company's wound up, is if there's any money left over, then you have rights to get your money back.
Yeah, and actually, to be fair, you're treated as a creditor. You know how we talked about the convertible note having debt and equity characteristics? This is where the debt characteristic comes out, which means you should get paid. In fact, this is the next clause. It tells us when you get paid. Well, it says you are junior to other creditors. So I guess if a bank has lent the startup money, or if suppliers have supplied goods and services, they are creditors. So you're junior to that. So pay them first, and then you're on par with all the other cares and any preference shareholders, and you are senior to ordinary shareholders. So that means that you're going to get paid after other creditors, and pari passu with other shareholders and preference shareholders, but you're going to get paid before the ordinary shareholders. So the company has to pay you first before they pay the holders of ordinary shares.
Dave, I'm going to stop you there as well. I'm going to say pari passu. What does that mean?
Oh, okay. That's sort of saying, well, if you have, let's say you have $1 million worth of cares out there, and in the dissolution, they're supposed to pay $1 million, but they only have $500,000 left to pay, all of you, well, you're going to get a proportionate amount of that. So you're going to get half your money back. And
got it. Makes sense.
You're on par with the other shareholders and preference shareholders. Right.
Okay. Yeah, I've heard that term bandied around. I was too afraid to ask.
Actually, I hope I've got that right. Okay. So that's what happens at a dissolution. Let's see, I guess, you've got some information rights, they're not, a lead investor will get fuller information rights. And, if you're not putting in a lot of money, maybe be fair and sort of, settle for this. There's some representations and warranties, that actually you can sign this agreement and you can abide by its terms. And then there are actually, you can see VIMA 2.0 has bolstered up the representations and warranties that the company might give. So when you're really at the earlier stages, it's highly unlikely, if you're not putting in a whole lot of money, you're going to be investing in negotiating a full set of representations and warranties. As you can see, the default here is quite a light set of representations and warranties. And this focuses on the shares that you're going to get, on conversion of your care, and that they're going to do good things with your money that you're putting in accordance with the business plan or the budget, which they've actually given you. So they're going to do what they said they will do. And there is a focus here as well on no legal action or proceedings or arbitration. And that's, something you might ask for in due diligence, and you get confirmation of it in these representations and warranties. Sorry, it kind of just got away from me. And this one here focuses on agreements with basically related parties. And, investors might ask that question, are there any agreements with related parties? And this gives you a representation here, which is a little bit more precise about what we mean by related party transactions. And then it also has the company promising not to redeem or repurchase shares or issuing any preference shares other than pursuant to an equity fundraising. And the concept here is, I guess it's another way of saying you're going to use the money for what you said you'll use it for, which is to grow the business in accordance with the business plan. You're not going to go and return capital to your shareholders. You're not going to go and use that money to pay off your current shareholders like some sort of Ponzi scheme. Does that kind of make sense?
No, it does, and I have to admit, I was looking at those. It didn't make sense until you just explained it right now, and I'm glad that we've covered that one off. The other question I have is with regards to if we were to look at the maturity date, and let's say the maturity date has expired. Now, is it by default that the conversion happens immediately, or can you negotiate to say, look, I want to give you more time to... Is it a hard and fast, like if that maturity date expires and we've gone past, do you have to convert to shares?
You don't have to convert if you just adopt the VIMA care position. There's that word there. The investor may elect. Okay, so the investor has a choice to obtain shares. Yeah, and I think sometimes you might see, maybe investors are putting in more money might say, oh, well, okay, I want that choice, but actually I want the best preference shares you've got out there. I don't want ordinary shares, and I want it at a particular price because, well, you really should have gone off and done that equity financing instead.
Yeah. Okay, makes sense. But the other question I have as well is when you sign this agreement, and I was talking to a founder who had an angel investor who had signed the agreement and then went home to his wife, and his wife scolded him and said, you should have spoken to me about this. Now, he then sheepishly came back to the founder and said, by the way, my wife's really not happy about this. And
Okay.
what happens in those circumstances? Now, the founder in this case
Oh.
actually gave him money back. He
Yeah.
gave him money back and cancelled the
Yeah.
agreement. But what's the general rule of thumb in terms of those scenarios where you've made a
Okay.
commitment and you can't fulfill it?
Well, that was very good of the founder to give the money back. But from a legal perspective, there is no out clause for my wife is happy with me. Yeah. So it was really in the gift of the company to do that.
Right. Okay. And we've had this discussion separately. I think me and Razi, when you sign the agreement as an investor, what type of period do you have to actually fulfill on the investment? Let's say you're going to put 10,000 in. How long reasonably is it expected that you give that 10,000 to the company?
This agreement and SAFE also assumes that you do it simultaneously. The moment you sign the care, you should have put the money in. So this recital here essentially says, hey, thank you for putting your money in. As a result of your putting the money in, we are issuing you these rights in this care. Yeah. So it just assumes it happens simultaneously. But I guess in practice, it's really up to the company and the investor. If it's months away, I think the company might get a little upset.
Yeah. I mean, we've had instances where we've seen angels come in and they've signed the agreement and haven't fulfilled on their obligation, but then it's held up future fundraising issues as well. Like, for example, like a VC will say, well, I'm only going to put money in until you can show me that you've got all of the other commitments, not just soft commitments. I want to see that money in the bank. And it creates a real mess for the founder if one angel investor decides that, you know what, I made this agreement, but I'm not going to fulfill until I've got my wife's approval, and she's going to take like 3 months to...
Yeah. Well, I think, sometimes you see this, I mean, you don't have that particular bell and whistle in the standard care. I think it's already quite full of bells and whistles, and you have to be careful in customizing it. But the other provision that you sometimes see, which this one is missing, is a condition precedent. So, and conditions precedent are more relevant where you've got a situation where the investor says, okay, this looks good, I'll sign, but I'm not going to give you my money just yet. I've got a few conditions precedent. I need to go home. I need to check with my spouse. Or, more usually it will be, oh, you've got, I know you're going through this restructuring and your, Singapore's going to be a holdco and it's going to hold all the shares in, a subsidiary in Indonesia or somewhere else. Okay, once that's done, because I'm not putting money into just a shell company. I'm putting in money into a company which has shares in a real business, right? So once that's done, I'll put my money in which case you might have additional provision around conditions precedent.
Got it. Okay.
Yeah.
That's where the value of conditions precedents come in. If you've got some stipulations, you can put them in, and then it's up to the founder and the investor to agree what goes in there and what their expected obligations are on each side.
Yeah, and depending on how far you get, I mean, with all of these provisions, you can have it with greater precision, which usually means more words, or you can kind of have it, you can have it less precise. So some of the more precise provisions might also provide for, well, a long stop date. It might say, well, if these conditions precedent aren't satisfied by a particular time, then, all bets are off. This agreement just terminates. You're not getting my money, but then I can't come ask you for shares later on if you do have an equity financing.
Yeah. It makes sense.
Yeah, I was going to say, initially when I was looking at the VIMA framework, I thought because we have VIMA now, maybe startups don't really need to engage a lawyer's services. But after hearing you and all of these little fine-tuning that needs to be done, it's clear that you still need legal advice when you're going about navigating all of this.
If you want to do it to that degree of precision. So I'm not trying to talk my profession out of a job. But I think where I see, from a practical point of view, I think it tends to be the lead investors who will look at this very, very carefully. And I like Osman's insistence on the MFN clause, perhaps that might help investors who are putting in smaller amounts of money, to get comfortable with things. Otherwise, you can see, well, and if I were advising a startup, I would say try to keep this consistent. Don't agree all sorts of bells and whistles with one and not the other, and it's not worth the small amounts of money, because then all that money goes into it's money and effort as well. Come up with what you think is a fair deal for all of your angel investors and then stick to it.
No, it makes sense.
So beyond the VIMA framework, beyond the CARE agreement, as an angel investor, when we are looking to invest in one of these exciting startups, what else should we be looking at, or what should form our due diligence process? What kind of paperwork, what kind of documents should I be looking at and asking the startup for as part of due diligence?
So I can only speak to legal due diligence, and some in the accounting profession or some investment bankers might say, legal due diligence is not terribly important, because the legal due diligence really focuses on some really fundamental items at the startup stage. So if you're looking at a startup and it's really got a concept, perhaps it's testing out a concept and it hasn't got very much, say it's maybe a year old, from a legal perspective, I guess you'd want to check off the fundamental items. So you'd want to ensure that the cap table is as they say it is, that they haven't issued a whole lot more shares, and actually your proportion of the company is going to be a lot smaller than you thought. So check out the cap table, and you might do some searches on ACRA to figure out what the cap table is at this point in time. Of course, it doesn't tell you much about what it's going to look like later on. You might ensure that the company actually exists, and you can do ACRA searches for that. You might, potentially, if you're worried about litigation, you might have a lawyer help you with some litigation searches to see if any claims have made it to court. If you think the startup actually has IP, it may be, or you think actually the founder has been working on this for a while now, and there is IP, there is intellectual property, there are some assets. I want to make sure that actually all of that IP belongs to the company I'm investing in, not just the founder, right? And so you might have a look at that. But I'm not sure to what extent angel investors look at that. I certainly know, acting for VCs and lead investors, they will certainly do so. I'm sure you can always ask that question. And if you've got a very organized startup, maybe they've got, a Google Drive full of documents that they're, providing to all investors. So that's what I might look out for.
So from what I'm hearing, you need to take a look at the cap table. You need to take a look at how new the company is, whether it truly is a startup on ACRA, and taking a look, asking a lawyer if there's any legal claims being made against.
Yeah, or potentially ask, perhaps one of the other investors has also asked, and the startup has produced a litigation search. The litigation search will be as at a particular date. Perhaps you can ask about that, or you might say, "Gosh, they only started 2 months ago. How much litigation can there be against the company?" Yeah.
This has been really fascinating, just for me specifically, because I come across this paperwork a lot, and we always, both Razi and myself, get asked this question all the time. What does the terminology within this document mean? So what you've gone through here has just really helped flesh out some of that with good examples, and I found that really useful. And at least we can go back to the VIMA framework, and there's a document as well on there, I think it's called Lexicon, which goes through all the different terminology and what it actually means. And I'd recommend that to anybody watching, to go and have a look at that and have a look at what that what that actually means now. There's the model legal documents link below, and what you can do is go there. There's a lot of lexicon documentation which will go through all of those. I think we've covered off the major points here. We've at least gone through how a care agreement or a safe note should look like, and what should be in there, and what if there are anything taken out. I think the key point that you brought out, Faith, was that even if people take something out, it's not to be construed as a negative or seen as somebody trying to swindle you out of your rights. It's more around keeping the document as simple as possible, making it as standard as possible, and making it easy to read and easy to execute. I think that's the key point I'm taking away from some of the comments that you made here as well.
Yes, and that's right. And sort of, the startup sort of customizing it, because there's really quite a few bells and whistles in the care.
Yeah.
Yeah.
And the question also is, Faith, if any one of these startups who are watching and listening to this particular episode, if they want to get in touch with you, how best can they reach out to fsLAW and yourself?
Oh, you're very kind. We're on a Google search, so we've got a website, and please do feel free to link in with me. I'm on LinkedIn as well, my details are on our website.
Thank you for sharing that, Faith, and thank you for spending time with us for this particular episode and bringing us through all of these legalities and helping us become a bit less clueless about the VIMA framework and also what is a care and a safe document.
No, thank you for the opportunity. And it's actually, I think this is mistitled because you're both very clued in capitalists.
We are slowly becoming the increasingly less clueless capitalists. That will happen over time. But thank you so much for spending time with us. And for everyone who's been watching, if you enjoyed this particular episode, please remember to like, comment, and subscribe, and we'll see you in a future episode.